Welcome back, estate planners. This is part 2 of our estate planning Hot Docs document assembly tutorial. In part 1, we covered how to open Hot Docs user, how to create an answer file, the document assembly interview, and document preview. We ended part 1 by saying, let's see what the document looks like in the document preview tab. We'll pick up there.
So you see that these blanks have been filled in. There's 3 children with the names of the children. There's the residence provision. Article 2 in the revocable trust typically deals with what happens while the grantor is alive, and it includes provisions that deal with the retention of the principal residence or real estate while the grantor is alive. So that's what those provisions are. Article 3 talks about what happens when the grantor dies. Basically, it's paid debts, expenses, taxes. And here's the tangible personal property provision. Here's the provision that says spouse gets the residence. And here is marital deduction formula provision, where we have the outright provision for the marital share to the spouse, and the exemption share goes to the family. We call it the family trust, but otherwise known as bypass trust or exemption trust or B trust. Here is if spouse does not survive, it gets divided up into separate shares. We see we haven't given the first distribution age for the separate share trust yet, so it shows that we haven't answered that prompt yet. And the rest of the document, there's going to be lots of unanswered questions, but there's the separate share trust for the child, and I'll just go down. These are successor trustee provisions that we haven't gotten to yet, and our answers will cause these blanks to be populated with the right answer. Business retention provisions are here. These are the generation skipping tax provisions. So let's go back to the interview. I want to keep pointing out that this is an important screen, the document review screen. When you get to the end of the interview, you'll be able to export all this stuff to a Word file that you can edit. And I want you to know that you can copy from this and paste into the Word document if you want to. And I'll try to explain a little bit later why you might want to do that. Here we are back at the interview, and it's going to be separate share trust. In this case, 1/4 at a specific age, another 1/4 at another age, and then termination. What was the age I picked for termination? It was 40. Okay, at what age should the trustee be directed to make the first significant principal distribution? We'll say age 28. This has to do with the formula. The formula is based on the federal exemption unless you include one of these cutback provisions. The federal exemption is well over $5 million now. So that family trust that we just looked at would be over $5 million if the client had sufficient assets for that. But that would cause a Connecticut estate tax for Connecticut residents, and it would cause a New York estate tax for New York residents, at least until the New York exemption gets phased in. So instead of setting up a situation where there'd definitely be a Connecticut tax, we'll cut back the family trust share, so that it will be no bigger than the Connecticut exemption. So you might want to take a look at the cutback provision in the doc preview tab, and you'll see that it is that paragraph 3. It says, if I'm domiciled in Connecticut at the time of my death, and the Connecticut estate tax may be reduced by increasing the marital share and decreasing the family share, the marital share shall be increased and the family trust share shall be reduced to the extent a Connecticut estate tax reduction will be achieved. Should the client's spouse be presumed to survive, you'll want to look at the assets and relative sizes of the estate and whether it makes sense to have a provision like this in here. For now, we'll say yes. And then we have options for provisions to include in the family trust. These 2 are preferred, that's why they're checked. It's income to be paid to spouse with power to pay to descendants. You wouldn't want to check 1 and 2 because 1 is income to spouse only and nobody else. We have principal payable to spouse and to client's descendants at discretion of trustee. We also have the power in the spouse to withdraw 5%, a lifetime power in the spouse to appoint to client's descendants, and a testamentary power to. This really is our normal family trust, where the idea is to give the surviving spouse the maximum benefits and flexibility and power without jeopardizing the goal, which is to make sure that the family trust is not part of the surviving spouse's estate when the surviving spouse passes away. In the separate share trust for the children, should the child have a testamentary limited power to appoint? The answer is typically yes, but sometimes no. We can include a special guidance to the trustee about education, about payments for education and weddings and business opportunities. If you want that in here, you click yes. If you want to see what it looks like, you click on Document Preview and go to the separate share trust for the child, and you see the guidance that we're talking about here. If that question had been answered no, this paragraph would not be included. We'll keep it at yes. Include anti-alienation and spendthrift provisions. Typically haven't used this in Connecticut. Have done some dynasty trusts and Delaware rules where we would include this, but typically the answer is no in Connecticut. And we have provisions for a trust committee to deal with decisions relating to removal of trustees and appointment of successor trustees. It's kind of experimental. You may want to take a look at it, but for now we'll answer no. And we'll get into the more traditional successor trustee questions. So who's going to have the power to remove a successor trustee? Is it going to be spouse or adult children, spouse or adult descendants? That would mean the majority of adult descendants, or whether it's spouse and committee or different possibilities. So typically it would be spouse or adult children. That's the default. But we'll show you what that looks like. Document Preview, we'll go to successor trustees. So this is the removal provision here. If you go back and you change the answer to spouse or committee, let's see what happens. In addition, after my death or incapacity, the trust committee shall be authorized. Now the thing is, before we answered that there would be no committee. So if you're gonna answer that as committee, you're gonna need to click yes here. That looked like something I'm going to want to change the way this is handled, because I don't want this answer to be inconsistent with that answer and stay the way it is. So I'll have to change that, but for right now, keep that in mind. We said no to the committee in a previous question, so this would be inconsistent with that. So let's make it consistent for now and move forward. During the grantor's lifetime, the first choice for initial co-trustee, and that might be the grantor, is unable to serve, who should serve as successor? So, who's going to be the grantor's successor? Our grantor is Howard Smith, right? By the way, if you need to look at the answers at any time, you've got a record of the answers under this tab. This is a record of the questions unanswered. This is the answer summary. So it can be useful to go through, if you've forgotten how you answered something, to go through and look there. So let's keep going. We're talking about Howard Smith's. Let's say it's his brother Charles David Smith. Now this is while he's alive. Don't forget Mary Smith is the co-trustee. And if she can't serve, who should be successor? And so if either Howard or Mary can't serve, maybe the best thing to do is appoint David as the successor. So we'll put him in there. So he's successor for both. When the grantor dies, you go through this phase where the settlement of the trust is more like an estate administration, and we call that, in that case, we call it the terminating trust, and we have a trustee of the terminating trust whose job is very much like an executor's job. These are the selections for that, and it's not unusual for the trustee of the terminating trust to be the surviving spouse, but there are other selections here. What is the name of the person who is the client's first choice for sole trustee of the terminating trust? That's going to be Mary Smith. And then the second choice, let's make it David Smith. Keep things consistent. Now it'll be trustees of the trust that are going to be for the surviving spouse's benefit. This could be any type of marital trust, plus it also includes the family trust or exemption trust or credit shelter trust, whatever you want to call that, bypass trust. It's not unusual for it to be two trustees. This one's two trustees with the possibility of a bank. This one is to non-bank trustees and may include spouse. It's not unusual at all to have that situation, so we'll click on that. Is the client's spouse going to serve as trustee? We'll say yes. Who would be the spouse's co-trustee? And we'll say David Smith again. And if David can't serve, who will? Let's say Ellen Smith. And then we have trustee selections for the separate share trust for the children. We'll say one individual trustee. We'll just keep with David Smith and with Ellen Smith as a backup. And there's a spot for a third one. Now, if you don't have a name, don't worry about it. Put in a blank. You can edit it or fill it in later. Should the beneficiary serve as a co-trustee? Now, lots of times, after talking to the client, we do suggest this as a possibility. It can be a good learning situation if you have the right co-trustee. So for now, we'll put in yes. The beneficiary can be the co-trustee. Then the question is, what happens? How does it work if all these people you named as trustees can't serve? Who's going to appoint? So we have these different selections, and it's not unusual to have the spouse appoints a successor trustee, and if spouse can't, adult children will appoint. We have some special provisions if a Chipman Mazzucco attorney is selected as a trustee or an executor. We have special provisions that deal with firm's power to remove that selection. The idea being that it's not really the specific attorney that's appointed, but the firm. So in order for the firm to have some oversight over that, there's provisions to deal with that. But in this case, there's no firm attorney who is involved as a trustee, so we answer no. I mentioned a Delaware type trust before. We included a provision in here that's consistent with Delaware law regarding appointment investment advisor, but this isn't a Delaware trust, so you'd pick no. We talked before about business retention provisions. So who owns the business? In this case, we'll say the client owns it. And we really should change this. There's no provision for a standby trustee, and this should be answered automatically, but I haven't built that in apparently yet, so we'll answer no. And that's the end of the interview. Once again, you can look at the document preview to see how things worked out. You know, there's close to 1,300 different files involved in this system, so there's bound to be glitches and mistakes that we haven't found yet. Just don't take it for granted that what comes out of here is totally 100% correct. Of course, we've done the best we can so far, but look for mistakes. Look for problems. Check cross-references. Check these article designations. Check for spaces that shouldn't be there. It looks like there's one there, which is annoying, between the exemption trust, family trust, and the separate share trust. I would have thought I would have handled that by now, but apparently not. Checking through to see if there's anything obviously wrong with this. We call this the ultimate catastrophe clause, where if none of the family members, that's the children, grandchildren, other descendants, survive the client, what happens? And this deals with that. You'll see throughout here some provisions that deal with retirement account property, and the idea is if there's retirement account property payable to a trust, required minimum distributions based on the life expectancies of the children and nobody who's older. And so you'll see language in here specific to the retirement account property, which is designed to make sure that no retirement property goes to people who are older than the children. So that's why in the ultimate catastrophe provision, you'll see provisions related to retirement account property. You'll see it in the trust for the children as well. To make beneficiary designations easier in life insurance beneficiary designation forms, we included this provision in our Article 9, and it relates mostly to retirement account property. The idea is that if retirement account property is made payable to the trustee, it's not going to be used to pay debts and expenses and taxes. It's going to go to the trust for the children without being exposed to those expenses. You'll see the successor trustee provisions here. See that blank that was there? If you click on that, you can actually answer the question. So keep that in mind. Or if you see a misspelling, just click on it, answer the question. Everywhere that name appears in the document should be fixed. You'll see in the editing process it might be necessary for you to insert page breaks. This doesn't calculate where page breaks should occur. I mentioned before, business retention provisions, that's what this is. Also generation skipping tax provisions, that's what this is, and then the end. So random spaces and page break things that we need to fix. But for the most part, it looks pretty good. So we'll go to the interview and we'll say, send the assembled document to Microsoft Word. There we go. And here is your revocable trust. Now this you can edit. The edits should be consistent with the style and syntax used. Don't incorporate new defined terms. I mean, for example, we use descendants instead of issue. Don't start using issue. It's important to maintain consistency throughout the document. Now, if you get to a place where you think, oh, I wish I had used another provision. I wish I'd answered a question differently. Of course, you can answer the question differently and generate the document over again. Or in working with the system, you know that you can get to another form in the system by answering a question differently. Just keep in mind that you can go back to the interview. You can navigate through the questions this way. You can answer a question differently. Let's say you want to make a gift of cash. And so you answer a question about that. Are any of the gifts unconditional? That means not conditioned on any fact other than the beneficiary surviving. And you click on that. No, I'm not going to say it's conditioned. Number of cash unconditional beneficiaries. Let's say there's just one. What's the name of the person? Let's say Ellen Smith. And let's say it's $50,000. The point I'm making here is, if you think you might like a different provision generated, or go to something that you'd like to be able to paste into the Word document, you can go answer that question, and then I give the sum $50,000 to Ellen Smith. If Ellen Smith survives me, you can copy that and then paste it where you want to put it in your Word document. It might go here. Then you'd have to change C and D afterwards. But the point is, you can get to different forms by answering questions differently. You can get different forms in the document preview, then copy it and paste it over to the Word document.